I'm A.G. Harmon and want to introduce the second of our presentations in this year's Student Scholar Series, this time by third-year student Erin Callahan. Before I introduce Erin, I'll introduce the respondent to her presentation. Yoda Soros is Senior Vice President, General Counsel for the National Center for Missing and Exploited Children, the NCMEC. As General Counsel, Ms. Soros provides legal guidance on litigation, contract, intellectual property, and policy-related matters for each of the National Center's divisions and branch offices. She also works with the National Center's Board of Directors on corporate governance-related issues and oversees outside counsel and in-house attorney staff on all legal matters relating to the organization. Ms. Soros first joined the National Center as an attorney for the International Missing Children's Division, currently part of the Family Abduction Unit, in 2006, and prior to joining the National Center, Ms. Soros spent 7 years in private practice as a litigation associate with 3 major international law firms in New York and here in D.C. While in private practice, she focused on domestic and international litigation matters, as well as domestic and international pro bono representations. We thank her for being part of the program today. Now let me introduce today's student scholar, Erin Callahan. She's a graduate of James Madison University with a BA in International Relations and minors in Spanish and Economics. After college, she worked at the International Rescue Committee and Refugee Settlement and the Commonwealth Catholic Charities as a refugee employment coordinator and interned for several months in Ghana for a grassroots organization dedicated to stopping child labor. That experience influenced her to choose the topic that she'll speak on today. While in law school, she has interned for the International Center for Missing and Exploited Children, Council on Foreign Relations, the Tahiri Justice Center, the International Rescue Committee, and currently is interning for the Department of Health and Human Services Administration for Children and Families under the Senior Advisor on Trafficking in Persons. Here at CUA, she is a note and comment editor of the Common Law Conspectus. They nominated her paper for the competition, and we thank them for doing that and for being here to support her today. She is the president of the International Law Students Association and has participated in the Families in Law Clinic and the Immigration Litigation Clinic. I'm now going to turn the floor over to the second presenter in this year's Student Scholars program, Erin Callahan. The title of her presentation, State Laws and the Fight Against Child Sexual Exploitation, on Backpage.com. Erin.
Thank you all for coming today. I would also like to thank the Common Law Journal and Andrew Yingling specifically for his continued support in working through this. In addition, I would also like to thank Sandra Porchenko, who is my expert reader and assisted me through the writing process through this article that I started about a little over a year ago. Unfortunately, she was unable to be here today. So, like Professor Harmon had said, I decided to choose this topic because of my past experience in Ghana and then also working at the International Center for Missing and Exploited Children. I noticed that there was a number of gaps in legislation worldwide and then also here within the US. So first, I just sort of want to talk about what is human trafficking. So under the Trafficking Victims Protection Act, it's defined as the recruitment, harboring, transportation, provision, or obtaining of a person for the purpose of a commercial sex act. Now, human trafficking is not limited just to sex trafficking, but there is labor trafficking. Sex trafficking makes up about 70% of trafficking cases. Child trafficking is also a large issue that is occurring. Child sex trafficking victims make up almost about 50% of victims in cases in sex trafficking. The average age of entry is between the ages of 11 to 14 years old. Also, human trafficking is the second largest and continuously growing criminal industry in the world. It's second to, I believe, arms trade, and third is drug trafficking, and sometimes those interchange throughout the year. It's generating $150 billion worldwide. Also, within the US, there are 14,000 to 17,000 victims estimated to be involved in human trafficking. Initially, trafficking would occur on the street, around the block. But with the expansion of the internet and everything shifting online, so did sex trafficking. This has made it very difficult for law enforcement to prosecute traffickers and, in effect, identify victims. Two main websites that have been involved in the trafficking online is Craigslist.com and Backpage.com. Craigslist.com, I'm sure many of you know, is sort of a marketplace of where people can buy and sell goods and services. It also had a section for adult services where people could purchase body rubs, escorts, and strippers. Due to community pressure and requests by a number of attorney generals, Craigslist voluntarily took down the adult section of the website. With the destruction of the adult section of Craigslist.com, there was a huge shift in advertisements and solicitations online to Backpage.com. Backpage.com has the same structure as Craigslist, where someone can buy and sell services and goods online. So with this shift of everything being on Backpage.com with trafficking, Backpage.com now has 70% of all advertisements online for human trafficking and for escort services. The common problem that many state legislatures are encountering is the being able to identify and show that the ads are explicitly selling sex. I would argue, as I do in my article, that it is pretty clear that is what the ads and the posts are doing. The ads, I would like to compare them to almost drug trafficking and drug dealing. There's certain language, there's certain terminology that is used in all of these ads that are consistent with the practices of drug trafficking. Also, there was an FBI investigation, and in one of the state legislatures, a detective also did a similar investigation of 1,200 ads that were posted, and not one of them was a legitimate escort service. So next I would like to show you is a group of ads that is on Backpage.com. I'm going to point out some of the terms that are commonly used. So one is in-call and out-call, meaning that the victim would be coming to the John or the person who's purchasing the sex, and then also, or the John would be going to the victim. Also, there are indications that the person is under the age of 18. One of them is showing that the person has a cherry, so either that they're a virgin or under the age of 18, a minor. So I have taken away pictures. That is also something that really demonstrates that what is being sold is not just companionship. Much of these pictures are of girls in little to no clothing, in very disturbing positions, and even I've seen videos online of apparently what the girl is able to do. So if you can see in some of the ads, there's the in-call, there's out-call only. Down here at the bottom, it says caramel with a cherry, indicating that she's a virgin or under the age of 18. Also, you can notice that there's a sense of urgency in a lot of the ads. Catch me while you can, they just arrived, visiting for a short time. This is a tactic used by traffickers to disorient their victim. They will move them from place to place, and so they're unable to seek help if they have the ability to do so. And also, it keeps them from not seeing the same clientele. So, like I mentioned, there have been a few obstacles covering with state legislation and trying to enforce criminal statutes against not only those who are posting, but Backpage.com. One of the issues is one of the statutes that is protecting Backpage.com is the Communications Decency Act. This originally was passed in 1996 and 1997 for the purpose of protecting children from seeing pornography, but it was shut down by the Supreme Court, saying that it was unconstitutional. And the only section that's really up and available is Section 230, which grants several protections for an internet service provider. Now, an internet service provider is a website sort of similar to Backpage.com that allows others to post on their website. So under the CDA, an internet service provider is able to have complete civil immunity. As long as they are making a good faith effort to monitor and make sure that there isn't any exploitive content going on. In addition, an internet service provider is not able to be treated as a publisher or speaker of the information that is posted. So that creates an issue because many state legislations have been trying to hold Backpage.com accountable for the posts that are occurring. In addition, Backpage.com has argued that this is an infringement on the First Amendment, the right to free speech. And so in trying to regulate the posts and the advertisements, not only are they holding Backpage.com accountable for it, but they're also treating them as the publisher, even though it is from a third party. I just would like to point out two other important parts of the CDA is the impact on state laws. So although Backpage.com has complete immunity from civil liability, it does not have any impact on criminal law. And this plays into the impact on state law. There have been many arguments that the state laws should be preempted by the CDA because of the civil immunity clause and that it does not expressly address the impact on state criminal laws. But in my article, I argue that under the no effect on criminal law section, which also states that it should have no impact on enforcement of any federal criminal statutes, but also is specifically related to Title 18, Chapter 110, Title 18, for child sexual exploitation. But it also says that the state laws should not be construed to prevent any states from enforcing any state law that is consistent with the section. So I'm presenting the argument that that means that the state laws, the state criminal laws, as long as they are consistent with a federal statute that is consistent underneath the Communications Decency Act, they should be able to enforce their criminal laws against Backpage.com. That still means that we run into the issue of treating them as an internet service provider. So it does get a little confusing, so I've just established a flow chart. So the first step of the argument is going to be to show that what is occurring on Backpage.com is not actually speech and is conduct. So if you're able to show that it is conduct, it will be a violation of 2 different federal statutes. With that being said, that if it is conduct, you're not treating Backpage.com as the publisher or speaker for the information. With that section, you're just focusing on the post and making sure that in arguing that it's conduct and not speech. With that, we take the second step to preemption. And so I wanted to reiterate the no effect on federal criminal law. And that if you're able to argue that it is conduct and that it's criminal conduct, you should be able to not be preempted by the CDA based on the impact of the state law and the criminal law subsections, as long as the state laws are consistent with the federal laws. And then you should be able to hold Backpage.com accountable for criminal liability. There have been 3 cases in 3 different states that have attempted to amend their trafficking statutes. They're in Washington, Tennessee, and New Jersey. The issues that they've run into is when amending their trafficking statutes, they addressed specifically advertisements and speech. They were trying to regulate speech. And so that's why I continue to present alternative arguments for demonstrating that what is going on is actually conduct and not speech. New Jersey was one case in one state that attempted to change their amendment a little bit different. Tennessee really followed Washington's suit and just did the same exact thing. New Jersey tried to get Backpage.com under commercial speech, which they ran into the same problem of treating them as the publisher for the posts. So how do we demonstrate that what is occurring on the adult section of the website is conduct and is not protected under speech? There are several cases that address this, that address speech as conduct. One is U.S. v. Burnett in demonstrating and assisting with the manufacturing of drugs. U.S. v. Freeman was where the gentleman was presenting seminars on how not to participate or how to violate tax laws. And then Rice v. Paladin was where this was the first time that a publisher was held accountable for a criminal act. The book that was published gave explicit steps on how to become a hitman and how to murder someone, and this was the first case that they were able to do that. The most important case and the kind of the standard that I use in my argument is Gimity v. Empire. And they say that it's not speech and it's not protected if what is occurring is the integral part of the conduct in violation of a valid criminal law. And from the ads that were shown and posted, those are a major element of prostitution. The actual solicitation, there were indications of how much money the person was going to be offering. I know I had taken out the pictures, but they're very explicit pictures, in addition to all the terms that are used on the page indicating the different parts to the act of the prostitution and the commercial sex. So that is my first argument for indicating that it is conduct. Oops. Okay. And so the second part of the argument was the preemption. If state law conflicts with federal law, then federal law preempts. And so that brings us back to those 2 subsections of the CDA, the impact on state laws and criminal laws. So my suggestion in my article was that if state legislatures were able to model and keep their laws consistent with a criminal statute such as the TVPA or 18 U.S.C. 1591, which is protection against child sexual exploitation or criminalizing child sexual exploitation, that they should be able to hold Backpage.com accountable for the criminal conduct that is occurring on the website. So although the argument could be made that Backpage.com is not the ones that are actually participating or not actually soliciting, under 18 U.S.C. 1591, they also have you are also able to hold them accountable if they benefit financially or receive anything of value through the person who is actually doing the trafficking. Backpage.com offers free classifieds except for the adult section of the website. They charge about $12 to $15 per ad, and that is where all of their money comes from. In addition, the intent for reckless disregard of the fact, and since my article focused on children specifically, the rest of the statute does say that there's force or coercion, but since it's under the age of 18, You do not need to know that that's occurring, but the fact that they are under the age of 18 and engaging in this commercial sex act is does need to be shown. And I argue in my argument that this is reckless disregard. As I go back to the ads of the pictures that are on the ads, the statistics and the data that has been collected, and then also the community outreach and pressure, that it's reckless for them not to be knowing what is going on and that is what is occurring. For 1,200 ads to be investigated and not one of them is legitimate, that's reckless disregard. So the point of my article is not necessarily just to attack Backpage.com. It is supposed to be to show an alternative to attempting to curb child sexual exploitation. So in essence, another argument that could be presented is that what is occurring is commercial speech. Unfortunately, you would not be able to hold Backpage.com necessarily accountable because then they do fall into the protection of the CDA. But if it is commercial speech, then that means that there is limited protection. And so I used the Central Hudson test to determine if it was commercial speech, and that if the regulation would not be impeding on the First Amendment. So if the regulated speech concerns an illegal activity, prostitution and sex trafficking is illegal. If the speech is misleading, that it does not apply here. But if the government's interest in restricting the speech is substantial, the regulation in question directly advances the government's interest. The government has a very strong interest in protecting its children and from curbing sexual exploitation, and that it's narrowly tailored. Again, I go back to the data and what has been provided, that there's really sort of no other way to address the issue except from making people unable to post for the solicitation of sex and child trafficking. So I go back to my original arguments. So my recommendations is that the speech in the adult section of Backpage.com is actually conduct, and it leads to an integral part of the criminal act of solicitation and commercial sex and human trafficking. And then I believe that if states are able to model their state legislations very closely to 18 U.S.C. 1591 and the Trafficking Victims Protection Act, that they should be able to hold Backpage.com liable. And I'm pretty sure that it has been demonstrated that they play a major role in showing the direct participation in trafficking. Thank you.
Microphone and ask the other to conduct response.
Sure. Well, I want to thank Erin for obviously all the time and great effort that she's put into this really important issue. Certainly at the National Center, trafficking of children and all issues related to child exploitation are issues we spend a lot of time looking at and also trying to figure out solutions. So I thank you for putting your thought process to this as well. I wanted to talk a little bit about, I think, one of the core elements to your paper and your presentation today, which is the concept of trying to convert the Backpage ad, let's say, or whatever comes next, whatever company might come next, that ad from speech to conduct, which I think is a little tricky to do. And you cited 3 cases, one that was publishing drug instructions, one that was basically publishing a hitman book, and then a seminar that was being delivered on tax evasion. So, when you look at those 3 scenarios, really the delivery of the content or I'm sorry, the content that was actually being delivered was, you could say, per se illegal, without knowing the details of the seminar, et cetera. In this context, you have, what is, at least at first, presumably a publisher who is putting up ads that have a lot of different features, and you named some of them: photos, words, maybe a price, maybe other details, maybe some, what you would suggest would be terms of art in the sex trade, in-call, out-call, things of that sort. Really a lot more factors are going into the creation of that conduct, it seems, than in the case law. And when you look at the Backpage Act, could you talk a little bit about how you take those various elements of speech and whether individually they constitute the conduct, or whether you have to look at the totality of the ad to get there?
I think that, and I think that this issue is different from the 3 cases that I had mentioned, because the posts that are online, that is the illegal act, the solicitation of sex, and so whereas I think the other cases may have been a little bit more attenuated, where they're trying to explain how to do something, this is the actual act. And so to your point of, to your question of the posts and how do you determine if the solicitation and the trafficking is occurring, I do think that, I think the totality of the circumstances and the evidence around the post strengthen the idea and the concept that they are soliciting sex. And so, I mean, none of the posts are saying in what I guess would be like common, the common society's notes of, oh, I'm selling sex here, but they do have the terms that are used, and just refer back to the terms and the different language that is used in drug dealing. I mean, that's how many investigators are able to make drug busts, because of what is overheard, because they know the language that is occurring. But it does take more than just for someone talking about heroin to, in whatever context it is, to make that arrest. You have to know all of the different facts and evidence that go into it. And so I think that's the same with the post. You do have to take into consideration all of the other elements on the advertisements.
So if we take that just a step further, and maybe break down some of the ads, what if it was a photo and a phone number? Or what if it was a phone number and a simple text, something like, I'd love to have a good time with you tonight. I'm great fun, let's go out tonight. Do you think that tips in? And at some point, how much interpretation is being done by a judge or whoever, maybe the decision maker here, to actually ascertain whether that's conduct? Mm-hmm.
Well, I think it's pretty common knowledge that the escort section of Backpage.com is used for the solicitation of sex. And so for someone to say, I want to go hang out with you, let's have a good time tonight, you don't ever see that on the section, but also it does seem that they would post in a different section, such as like dating, if they really just wanted to hang out with someone. Are you saying so that their intent to posting on that section it demonstrates the further intent to solicit.
So if it didn't have the escort category, if it was, I want to have a good, here's my photo, I can show you a great time tonight, let's have fun, something you might read on a dating app as well. Mm-hmm. At what point does that become solicitation or not? Or is it only because it's under the escort section?
Well, before you go into the adult section of the website, you do have to sign off that you're above the age of 18, mm-hmm. because there is explicit content that is in this section.
Sure.
So I guess, now is the question in any situation if someone just has their picture and phone number.
I guess I'm trying to go back to the totality and the conduct and see if you get there because it's under the category of escort. Therefore, like you said there, I think you said common knowledge, maybe that those ads are presumably prostitution ads, or whether it is, what are the components that's making it conduct?
Right.
I'm trying to figure out really how you're getting to the illegal act, if it's the label that's put on it of escort, or if it's something intrinsic to the words and photos.
It's definitely intrinsic to the words and photos. And I think it's, like I mentioned before, it's sort of the totality of the circumstances. So you do take into consideration that they are posting in the escort section. Would I jump to the assumption that someone just with their phone number in another section was soliciting sex? Maybe not, but it does follow under, if they are posting in the escorts, I would probably have the inference that they would be soliciting. And I think it is important to take into consideration all of the pictures and the other language that is used.
Was the conduct argument raised in the 3-state legislative injunctive actions?
The conduct was not addressed because the state legislations were addressing speech directly. In the Washington bill, they were trying to regulate the advertisements and holding others who are, I believe, that provide post or space for an advertisement that has led to the solicitation of sex. They were trying to hold them accountable for that, and which goes directly against and conflicts with the CDA.
If there was no moderation that was being done on Backpage, and I'm not sure if you spoke to that during your presentation, but Backpage certainly advertises itself as having heavy moderation and review of any ads before they become public. Mm-hmm. If that was not in place and they were really kind of the proverbial bulletin board, here's a wall, put whatever you want to on it, I'm not going to look at it, I'm not going to take anything down. Does that remove them, do you think, from the speech as conduct argument?
Okay, sorry, I couldn't understand your question.
I can rephrase, I guess, what is their conduct then? If they really are just saying, here's an empty space on the internet, put what you want, no one's reviewing, no one's taking anything down.
If that was the only difference in the facts, I still think when they wouldn't have the good faith effort underneath the Good Samaritan section of the CDA. And then they also, because they wouldn't be monitoring, making an effort to monitor. In addition, I think playing into the pressure of society and the community that they wouldn't look into the ads in that section or the posts that are going up, that they weren't, then that would be negligent and reckless disregard on their part.
So you would make the argument that it's reckless for an internet provider to not monitor their content?
If they are from several different sources, if they are aware that these advertisements are coming from their website. There are many cases that in civil court that have been tried that the victims have said that their posts are coming from Backpage.com. And so if those cases are arising, then they would have the awareness.
So the argument would be that societal pressure is going to impose the obligation on an ISP to monitor or review.
No, I think the awareness that it's occurring from also the cases that have been tried, that the victims know that they're being advertised.
Was there any case law that you found while you were putting the paper together and looking at the speech conduct issue that that really talked about kind of this particular issue, when an obligation may arise, especially on the internet where there is a lot of kind of anonymous posting and some monitoring, and some areas where there's no monitoring. Where does the obligation come from, or where does the connection between the, if we don't want to say publisher, provider, let's say, of the space, where does that obligation arise? So in other words, what connects Backpage to the conduct if there is a non-monitoring scenario?
Then you would be able, I think that the Communications Decency Act does have that in place with the Good Samaritan clause, that they don't have complete immunity if they have the good faith of monitoring.
If they're monitoring.
Right, if they are monitoring. So if they are not monitoring, then they would still be able to hold them accountable for the publishing or the conduct.
Just to turn a little bit to one of your, I guess, kind of alternative arguments on commercial speech. So if it could be speech becoming conduct, and then there's an avenue away from the First Amendment under your theory, or it could just be commercial speech, period, because it's an advertisement. And even Backpage wouldn't say it wasn't an advertisement. I know in the Tennessee case, at least in that legislative action, they tried to raise the commercial speech exception to the First Amendment defense. What did the court hold there, and was it raised in the other legislative actions?
It was not, if I can remember correctly, it was not raised in the other actions, and the court held that the court decided that although if it was commercial speech, you still could not hold Backpage.com liable because of the CDA.
Do you think there's a way, in looking at the legislative language, which was all the same in the three states that tried to do this, given your paper is focusing on a potential legislative solution to this, is there a way for the wording of the statute to change that could possibly capture a commercial speech exception for Backpage, or could kind of refute what the Tennessee court found in dismissing that defense?
I'm sorry, can you restate the question?
Sure. Given the potential argument, which might be a little stronger than the conduct argument, that it's an advertisement, it's for the sale, presumably, of something, maybe companionship, maybe sex, that argument might be a little bit easier to make, let's say, that it is commercial speech, much less regulated. The First Amendment defense is already, becoming subject to a lot less scrutiny at that stage. Is there a way that if there was, let's say, a fourth state that tried to put forth some legislation now, that they could learn from how the Tennessee court rejected the commercial speech challenge to make the next statute stronger?
I did not go into as much detail for the alternative for the commercial speech,
Okay.
But that is definitely something to consider.
Okay. One issue too that there's a lot of different things going on in the Tennessee case. The issue there was raised, and you mentioned it in your paper, the fact whether the CDA immunity can act as total immunity from the suit. So whether it's sort of a front door immunity, I'm a publisher, you're going after something on my website, I can kind of waive the CDA and the case is over. Or whether it's an affirmative defense. So it's something that once you get into the case, you can say, you've charged me with, all these claims, but I'm going to assert CDA. You've already gotten into it a little bit, maybe discovery, but I'm going to be able to ultimately win. How did the Tennessee court handle that particular aspect? And, in your research, and this is an area that's kind of evolving a little bit, whether the CDA is a defense that comes later or whether it gets you out of the suit at the get-go. How did the Tennessee court handle that particular aspect of the CDA immunity argument? And again, is there any way, do you think, that a future state legislative attempt could kind of get in the door a little bit, even if Backpage is still asserting CDA?
Well, Backpage.com was able to enjoin the legislation, so they were able to prevent it from even being passed, so used against it. So it was, I believe they were using it as an affirmative defense, or using it before they could be charged
So
for it.
total immunity from suit
Yes.
from the beginning.
Yes, I believe that's.
Okay. Just see if I had any other kind of unique questions. The concept of aiding and abetting, again, a little bit different from the speech as conduct argument, but something that you talk about in your paper, especially for how you could possibly get Backpage on a Section 5091 case or TVPA claim for trafficking, period. There's been some case law against Craigslist and against other websites as well that have rejected some of the aiding and abetting arguments as to a website provider. Aiding and abetting is not an easy standard to make at times. Did you do any research or capture in your paper how Backpage could actually be tied to an aiding and abetting claim, assuming that it's a prostitution ad?
Right. I think the one case that comes to mind was Roommates, where roommates.com provides a forum for people to find roommates, and you can distinguish by preferences, gender, I believe ethnicity and age, and some of the categories that were presented went against the Fair Housing Act, and they were able to demonstrate that they were aiding and abetting because roommates.com was providing the drop-down menus and the structure for the posts. And so I think it would be a difficult argument to bring because it is a higher standard. So I think I think that would be difficult. But because that is brought up in a few other cases that because they don't set out the different identifiers. They do say what they should not be used, but they don't set that out that directly.
And they have, I think one other distinction with roommates is, like you said, it had some required drop-downs. You had to pick a selection. Some of those were not legal under the housing regulations. Backpage really just has open field. So you have to provide a title, an age, some kind of text if you want to, photo if you want to, but they don't require drop down of, let's say, sex acts that you'll perform or something of that sort. So they likely have contemplated how to get away from that. One other issue too that we were talking about right before is whether it's any weakness to the speech versus conduct or maybe even the commercial speech argument. Unlike the three cases that you talk about on the conduct where, there was one delivered product. There was a tax evasion seminar, hitman book, or your drug instruction manual as well. There was only one product there. That was the illegal conduct. Pretty simplified examination maybe there, as opposed to Backpage, which has tens of thousands of ads changing all the time, across the country, around the world as well now too. Some of which are, arguably explicit, laden with sexual content and videos, as you noted, et cetera, and some of which are much vaguer. So some ads which, I think most prosecutors would look at and say, yes, you could make an interpretation, you could use kind of a societal bias and say this must be for something more than, going for a cup of coffee. But do you think it makes the Backpage argument harder if there are legal and potentially illegal ads mixed in to make the conduct argument?
I think that the posts and the ads that I displayed, those were the tamest of the tame. And so I think that the combination, if there is any, I would argue that there isn't. I would argue that there really isn't a combination, and that how does the legal issue, does legislation impact that? I think that then it is sort of a case-by-case basis, looking at how does the ad fall under, and if it does fall under the child sexual exploitation statute. And then also the purpose behind arguing that it is conduct is not, it's to get out of the realm of and because it is conduct, to avoid to avoid the treating the internet service provider as the publisher or speaker of the information. It's that portion of the argument is not to necessarily tie in Backpage quite yet. It's just to show that what is going on the website is illegal, or at least under the sections of the adult services part.
So your premise would be that all the ads are conduct and potentially maybe de minimis. Some ads may be legal conduct if they don't contain any sexual ads or content or trade words or anything of that sort, and maybe the majority of the ads are illegal conduct.
Not all of the ads on Backpage.com are illegal. Under the adult section, specifically under the escort section, that they are soliciting sex, and that would be illegal.
That's your premise on that. So therefore, they're all illegal.
I mean, just from the data that has been collected and the research that has been done, and just even from past investigations through victims, it's just pretty clear that that's what is occurring.
That's great. I don't think I have any other individual questions.
I would like to say first, I like that you caught yourself saying the reason I'm arguing that it's conduct is because that helps my argument. Instead, you said because it is conduct. I like that. Good job. The other question I had was, I think that you're advocating an interpretation of the CDA and the federal criminal statutes and state statutes, and so you're finding your way as an advocate for how those things could be interpreted in a way that would complement them and allow prosecution. Did you think at all about whether there might be an amendment to the CDA that would more directly accomplish what you want to accomplish?
There have been a few efforts, especially by attorney generals, to amend the CDA. I haven't gone into great research on how and what specific language was used, but they haven't been successful. So there have been efforts to do so for this specific reason.
So you think the politics of trying to get Congress to do something means that you're better off working as an advocate within the...
Yes, and I think that's also why I focused on state legislation, just because they are closer to their constituents and to the people, and they have the ability to make a quicker and more direct impact.
What percentage of Backpage's income is based on the escort section? Is that established?
From what I have found, all of it, almost all of it.
Because there's one of the propositions of criminal law is that a provider of otherwise lawful services becomes an aider and abettor if, in fact, the vast majority of its income comes from criminal activity. Is the categorization of Backstage as an internet service provider what defeats the application of that principle, or is that?
So that's if I'm trying to understand the question correctly.
I set myself up as a shop which sells supplies for stamp collectors.
Right.
But I know that 95% of my business are from drug dealers who are buying less in envelopes to package heroin and cocaine. Right. So that makes me an aider and abettor of their sales, even though theoretically I'm just selling to any stamp collector who wants.
Right.
Now, stamp collecting supply houses are protected by a federal statute, whereas Backstage arguably is. So is the ISP protection that Backstage claims make it more difficult to charge them with aiding and abetting, whereas I, as the supposed stamp collector who's really just selling to drug dealers, can't claim a similar defense?
I think that the issue that will arise there will be the difference between speech and conduct, and I think that's why it's important to show that what is occurring is conduct, because then there is the protection of holding Backpage.com liable for what third parties are publishing. And so I don't know if the speech, so if the speech is, right, so if the speech is not conduct, then it is not necessarily illegal. Hold on, commercial. Okay, do you?
A lot of law enforcement agencies around the country intentionally place ads on Backpage, therefore leading to sting operations.
They do.
If you were to remove those ads altogether, would it force it more underground and make enforcement harder?
They do. I have 2 points for that. And I was informed recently today that there was a sting operation through Fairfax County that found someone who worked under the State Department who was going online. In addition, there seems to be a trend also with the ads, and I will ask my law professors about this, that there are disclaimers on the ad itself indicating that, or almost bringing the person in who is seeking the services as a contract. First, the person is stating they're agreeing that they are not law enforcement, and then the disclaimer is saying that the ad is not for prostitution, and that anything that occurs afterwards is by consenting adults. My question to that was, how is that sort of enforceable? And then where does the companionship and the consenting adult sexual act kind of cross?
I think it's not worth the paper it's printed on. I say that knowing it's not printed on paper. I mean, purveyors of illegal goods do that all the time, and
Right.
You may get a jury stupid enough to fall for it, but as a matter of law, it's not a offense.
Okay, great. Thank you.
Does it matter where Backpage is based? Like, if it was outside the country where the laws were, or a country where prostitution laws were totally different?
Is the purpose to prosecute the runners of Backpage, to shut them down, to sue them? What is the ultimate goal
The ultimate goal, I think, for also the amendments to the CDA and for a lot of the legislation that has been passed is to shut down the adult section of the website. The Backpage.com, I believe, is incorporated out of California. I may have to double check that, but they are worldwide, and it's similar to Craigslist. You're able to narrow down your searches to the specific state and city. So how does that impact?
No, I mean, if they weren't looking in California, but say in Brazil,
Right.
somewhere where I don't know, where all these things are, there's human trafficking, the laws on human trafficking are different. Or,
Yeah, it's a very good question, and Backpage recently sold itself to a Dutch company at the end of the year. So talking about where pornography might be, prostitution might be more legal, and that sale is ongoing still. The purchaser has not yet been disclosed. They are saying publicly at this point that their work process will remain in the U.S., which is mostly located in Dallas, where their operations are. And it remains to be seen, really, when the sale goes through, if that'll hold or if they will move wholesale abroad. But it's a question a lot of folks are talking about now.
Well, I want to thank Soros and Coach Erin for a great presentation. Erin, we want to present to you on behalf of the faculty a plaque for being one of our student scholars this year. Thank you all for coming, and round of applause for Erin.